now?
Well, the GDPR stands for the General Data Protection Regulation. It's the new European-wide data protection framework, and it comes into force on the 25th of May next year. It's needed because the way in which we collect and use personal data has changed tremendously since the Data Protection Act was enacted in 1998, some 20 years ago now. The GDPR is a more modern data protection framework which is intended to really reflect the way that we now process and use personal data. In terms of what you will have to do differently from the 25th of May next year to what you're doing now, the first important point to note is that the GDPR very much builds on the existing system of data protection. And as a result, many of the concepts, principles and terminology that you will hopefully be already aware of will remain the same under the GDPR. For example, the GDPR still is built around the concepts of data controller, data processor and the data subject about whom the personal data is about. Also, the definition of personal data is much the same. In other words, any information either on its own or in conjunction with other information that's known that can identify a living individual. And the data protection principles, which are the cornerstone of the data protection law, also remain fundamentally unchanged. This all means that if you're compliant now with data protection law, then that'll be a really good starting point for compliance with the GDPR. Having said that, the Information Commissioner hasn't referred to the GDPR as a game changer for nothing. You will need to do some things differently and you need to do some new things. So just to summarise, some of the main changes that you need to be aware of are, first of all, we have the principle of accountability. Now this is a brand new data protection principle which essentially requires controllers to be able to demonstrate compliance with all the other data protection principles through a variety of technical and organisational measures, such as having policies and procedures in place, undertaking staff training, documenting decisions when you're making decisions about data protection in the workplace, and of course keeping records of processing activities. Now some organisations will also have to consider whether they need a data protection officer, because that's mandatory in certain situations. But if they decide that they don't need one, then a good idea is to document that decision also. And building into the principle of accountability is the need for organisations really to carry out a data inventory exercise so that they can understand what personal data the organisation holds, where it came from, what they do with it, who they share it with, how long they keep it for and how they protect it. You'll also need to identify and document your legal basis for processing personal data. That's going to be very important, and that record needs to be maintained and will help every organisation with their ongoing compliance. Another big area of change is in relation to privacy information. So every organisation will need to provide individuals with certain information about how their personal data is being processed, and that's often referred to as a privacy notice. And the GDPR requires a far higher standard when it comes to privacy notice. So it has to be clear and intelligible, it has to be using plain language, and that's particularly the case if it relates to children's data. A lot more information also needs to be included in that privacy notice. For example, you have to set out the actual legal basis for the processing of the data, how long you're going to keep that personal data for. And that information has to be given to the data subject at the point in time that you're collecting the personal data from them. So this means that the organisation is likely to need a number of different types of privacy notice for different types of individuals. That might be job applicants, employees, volunteers or members of the organisation. Another big change is in relation to the breach reporting obligations. Now the GDPR for the first time will make it mandatory for every organisation to keep a record of all personal data breaches that occur. And there'll also be a requirement to notify the Information Commissioner's Office of personal data breaches that could result in a risk to the rights and freedoms of individuals. So, for example, if there was a loss of data that potentially could expose an individual to identity theft or fraud, then that would have to be reported to the ICO, and that would have to be done within 72 hours of becoming aware of the breach. So that's a whole new concept that organisations have to kind of get to grips with. And there is, in addition to the need to notify the ICO, a potential need also to notify individuals, the data subjects themselves, where there's been a personal data breach, if there's a particularly high risk to them. So an example of that might be where financial data has been lost, or special category data, so information, for example, about their health has been lost or inadvertently sent to the wrong person or something of that nature. And one final change to note, I mean, this isn't all the changes, just kind of the top ones that to refer you to, and that's in relation to your agreements with data processors. Now, the GDPR requires you, as an organisation, to make changes to any agreements that you have with organisations who process data on your behalf. So, for example, an IT service company who provides you with cloud storage, and these changes will need to be put into contracts that you currently have in place and any new ones that you're going to come into place after the 25th of May 2018, so that if your contract spans the current regime and the new regime, that you've got those changes in place to make sure that you're GDPR compliant.